Today's lecture will focus on Chapter 23, the agency relationship. Today in Chapter 23, we're going to talk about internal agency. In Chapter 24, we're going to talk about external agency. Agency relationships are very similar to contracts. Usually there are two parties to an agency relationship, the agent or the A and the principal or the P. Think about it from this perspective. Let's say you have a business and you have one location. Well, you can be at that location all the time to manage your employees and service your customers. However, let's say you expand to 5 locations. You can't be at all 5 locations at all times. Therefore, oftentimes you employ agents to carry on your business on your behalf. Let me give you the definition of an agency relationship. An agency relationship is when one person, the agent or the A, acts for the benefit and under the direction of another, the principal or the P. So again, we're looking at two players, the agent or the A and the principal or the P. Agency relationships are usually formed by contract. Hence, this is why we're talking about this after our section on contracts. Agency relationships usually are written, but they can be oral. They don't have to be written. In addition, the agent does not have to be compensated, which means it can be a gratuitous agency. Finally, although agency relationships are usually formed by contract, sometimes they can be formed even if they didn't intend to create one. That's called an implicit agency agreement. Who has the capacity to be the P or the principal? Well, a person can do anything through an agent that he could legally do, but nothing more. Thus, a minor who usually has a limited capacity to contract can have full capacity to contract and can be the principal, can act as an agent, okay, or can act as a principal. Who has the capacity to be an agent? A person can be an agent even if he or she doesn't have the legal capacity to contract. So minors can serve as agents. So this is a good slide to study about the basics of how agency relationships are created. Please write this down. All employees are agents, but not all agents are employees. Again, all employees are agents, but not all agents are employees. You can see that we have various types of agents. Let's first start with what's known as commercial agents. These types of agents do not usually maintain their own inventory of goods. They're usually, they take orders on behalf of their principal, and they're compensated based on the amount of sales they do. But these type of agents often have the authority to contract on the principal's behalf. Please note the difference between commercial agents and a sales representative. A sales representative, just like a commercial agent, is an agent. However, sales representatives do not have the power to bind the principal. Many of you are familiar with employees, otherwise known as dependent agents. Employees are under the control of both the principal on both the objective of their work as well as the means to achieve it. So for instance, a manager at McDonald's will be the principal and they will have employees who are agents. The manager will control what type of work to do and how they will do it. Compare and contrast an agent that's an employee with an agent that is known as an independent contractor. Independent contractors work according to their own methodologies. Thus, the principal controls the result to be achieved, but not the means used to achieve the result. So if you, for instance, let's say, for instance, you hire me to draft a living trust for you. Well, you're the principal, I'm the agent. You want the desired result, a living trust, but you're not going to tell me how to do it. So in essence, even though I'm the attorney and I'm the agent, but I'm an independent contractor and not an employee. Oftentimes, principals like to have independent contractors because even though they can't control the means used to achieve the objective, they will not usually be responsibility for either torts or crimes because they don't have control over how the agent, in this case the independent contractor, does the work. The following two slides look at duties. On this slide, we'll look at the duty that the agent owes to his or her principal. The first duty is a duty of loyalty, and this goes to the notion of a fiduciary. Fiduciaries are trusted to act in the best interests of another. So an agent is a fiduciary of his or her principal, must avoid conflicts of interest, and even the notion of an appearance of impropriety. However, moonlighting is allowed. Moonlighting is taking on a second job, so long as it's not in conflict. Finally, there's a duty of confidentiality, so the agent may not disclose the principal's secrets. The second duty of an agent to his or her principal is the duty to obey instructions. Thus, agents cannot substitute their personal judgment for the judgment and lawful instructions of the principal. So if I tell you, for instance, to go buy a Lamborghini, I'm the principal, you're the agent, and you as an agent go out and buy a Ferrari, you did not obey my instructions. The third duty is the duty to exercise care and skill. So thus the agent must act with reasonable ordinary care, the average reasonable agent. The fourth duty that an agent owes to his or her principal is the duty to communicate information in a timely fashion. Finally, the fifth duty that an agent owes to his or her principal is the duty to account for funds or property. Principals also owe duties to his or her agents as well. By far, the biggest duty that a principal owes to his or her agent is the duty to compensate for work done, unless it's a gratuitous agency agreement. So this obligation is usually implied. However, compensation from the principal to the agent may be contingent on results, such as a commission. Speaking of commissions, under the notion of a procuring clause, this may entitle agents to their commissions on transactions that occur after the agency relationship has been terminated. Second duty that the principal owes to his or her agent is to reimburse for expenses and indemnify for losses. So for instance, if I'm the principal and I tell my agent to go down to Santa Clarita to pick up an item for me, I need to reimburse the agent for his or her gasoline expenses for driving down there and indemnify for any losses. So for instance, if on the way down to Santa Clarita, the agent's car gets hit by a deer, I need to indemnify for the loss to the vehicle. So you reimburse for expenses and indemnify for losses. The final duty that the principal owes to his or her agent is the duty to keep accounts. So the principal must keep adequate records as well. Let's look at any liabilities owed between the principal and the agents. First, let's look if the agent breaches his or her duty. So if the agent breaches one of his or her duties, then the principal may deduct losses from the amount due to the agent if that breach of duty causes damages. Now let's say instead of the agent breaching the duty, the principal breaches the duty. So thus, when a principal breaches a duty owed to his or her agent, the agent, if he or she is in lawful possession of the principal's property, has a lien against it for compensation that's owed to the agent. So for instance, let's say a stockbroker who's the agent may hold shares of stock that he bought for his or her client the principal until the stockbroker is paid for his or her services. Just like all contracts must come to an end, all agency agreements at some point must come to an end. There are three ways that an agency relationship will come to an end. 1, termination by will of the parties. 2, termination by agency at will. And 3, termination by operation of law. The first way that an agency relationship may be terminated is by termination by will of the parties, or by what they put in their agency or contractual agreement. Thus, the agency agreement or contract should discuss how, when, and by what means the agency relationship ends, such as a period of time or the happening or non-happening of an event. So for instance, in the agreement, someone may be someone's agent for 6 months. After 6 months, you're no longer the agent, or upon the completion of an undertaking. So if I hire you as my agent to build me something, once you built it, the completion of an undertaking, the agency agreement has been terminated by the will of the parties based on what they stated in their contract. The second way that an agency relationship may be terminated is known by agency at will, at any time. Again, at any time. Please take note. Either party, principal or agent, can terminate the agency relationship at any time. However, even though a party has the power to terminate, doesn't mean that he or she has the right to terminate. Again, with an agency at will, either party, the P or the A, can terminate the agency relationship at any time. However, even though a party has the power to terminate, it does not mean that they have the right to terminate. So, there are some exceptions to the agency at will doctrine, which means you do not have the power to terminate. The first one is what's called an agency coupled with an interest. This arises when a power is given as a security. For example, let's say P, principal, borrows $1,000 from A, agent. P gives A the authority as her agent to sell P's diamond ring to satisfy A's claim, the $1,000, if P does not pay the loan back as promised. So P cannot revoke A's power to sell P's ring because this is an agency coupled with a security interest. The second exception to agency at will is known as legislative restrictions. So you can't terminate an agency agreement at any time or at will when it's based upon such criteria as race, color, sex, religion, age, or national origin. The third way that an agency relationship may be terminated is by operation of law. So the law, not the parties, but the law will terminate an agency relationship if certain events occur, such as the death or insanity of either the P or the A, the bankruptcy of either the P or the A, if the objective of the agency agreement becomes either impossible or illegal, such as an intervening illegality, or if the subject matter of the agency has been lost or destroyed. Final thing I want to talk about today is notice given to some outside third party. Now, as I said at the beginning, we'll talk about external agency next lecture. However, just because an agency agreement has been terminated doesn't mean that everyone knows about it. In essence, proper notice has to be given to other people as well. Thus, an agent or A may still be able to bind the principal or P on contracts with outside third parties after the termination of the agency relationship if the third party is unaware that the agency agreement has ended. Thus, The principal must give either actual notice or constructive notice to the third party that the agency arrangement between A and P has been terminated. Actual notice can be either written or oral. Written notice would be the best because that's the best evidence that proves the existence of the termination, or it can be done constructively. Constructive notice would be such as a notice in a newspaper of general circulation in the area. Finally, there are some times when notice does not need to be given when an agency agreement has been terminated. 1. If death of the principal. Well, if the principal is dead, he or she can't give notice. Second, loss of legal capacity of the principal. So if the principal goes mentally insane, you no longer have to give notice. Finally, impossibility of performance. This concludes our lecture on Chapter 23, the Agency Relationship, Internal Agency.